I think there's hope now for people that, after the Loper Bright decision, some others from the court recently, that the court's taking a lot more seriously enforcing the constitutional rules around this stuff and moving back to the people's elected officials the responsibility that they're supposed to have.
Well, I would think it would be hard for in a justice's mind to say on the one hand, Congress should have spelled this out. If they wanted to give you the authority to do it in Chevron, they should spell that out.
Yeah.
And then in this case to not do that.
Yeah. Well, and I think after Loper Bright, there's there's at least one risk coming out of Loper Bright, is that Congress might respond to Loper Bright by saying, well, instead of agencies interpreting, broad power for themselves, why don't we just give them broad power?
Americans are capable of achieving extraordinary things when they have the freedom and opportunity to do so. This is American Potential.
Welcome to another episode of American Potential. Hey everybody, it's Jeff Crank, along with the podcast's new host, David Fromm. Now today we're going to talk about a very interesting court case, but if you're wondering why we have a new podcast host, it's because I decided to run for Congress and won. So with me heading to Washington, we needed to bring someone new on to be able to continue to share your amazing stories of making a difference in your community. Now, I also want to note that this episode was recorded before January 3rd, which will be the day that I will be sworn into office. So, David, let's just take a minute and let everybody know who you are, how you came to AFP, and where you're from.
Well, I live outside of Chicago, in the western suburbs, with my family. And, I had a career in, probably 17, 18-year career in principally Illinois, right of center politics. And I had a consulting company, did a lot of campaigns, political consulting, and I decided hey, there's this group called Americans for Prosperity. This was 13 years ago, by the way.
Right.
That seemed interesting. And I had a friend who had looked into it and said, this might be good for you. And so I ended up applying and became the state director for AFP Illinois and led that. And as I'd like to say, after 5 years of doing that and making Illinois the land of opportunity and freedom that it is today, I became a regional vice president and joined you and have been doing that. So I gotta say, working for Americans for Prosperity has just been the joy of my professional career. It's been the investment in me and my growth, what I feel like I can accomplish. I wake up every day excited to hopefully win battles for, taxpayers, for ordinary citizens, hopefully for good. So it's been a blast. And this new chapter is super exciting to me.
Well, good. Yeah, we've been friends and coworkers for a long time. And Americans for Prosperity has been a great home for both of us. I'm 15 years into AFP, you're 13 years in. And so, but this is a great opportunity, I think, for you, for the podcast. You're going to just be awesome at this. Well, so congrats.
Good. Big shoes, or maybe a big microphone to fill, I guess. So,
there you go.
All right.
Yeah.
Well, so getting into today's episode, we have Casey Maddox on, who is the vice president for legal strategies. And we have him on to talk about a case involving a taillight out on a dirt bike. The podcast has talked about the administrative state and the impact it has on Americans. We shared how the administrative state is overreached by trying to get fishermen to pay to have monitors on their boats. But what happens when Congress gives away part of their lawmaking ability? And how much can they constitutionally give away? This is where the dirt bike comes in. The Ninth Circuit heard oral arguments on the case United States versus Pheasant that is challenging how much power the Bureau of Land Management can have. The case deals with this dirt bike, and if BLM has the authority to create and also enforce the rules they have created. I wanted to welcome Casey Maddox back to the podcast.
Hey, thanks for having me. And I had no idea when we were setting this up that we were going to have this news break on the podcast I'm on. So I feel honored.
Yeah, this is exciting. That's right.
Well, we just have to do it when our most important guest comes.
That's right.
So Casey, first off, just walk us through the United States versus Pheasant case.
Yeah, so I love this case. This is a very important case. This broad principle, right, as you described, this non-delegation question, critically important, I think, to our country. This is one of those things. It's like this quiet legal principle that operates out there that impacts, frankly, every aspect of our lives, and we just don't realize it on a daily basis. But basically what happened is a very common sounding story. It's actually a pretty entertaining story to me, not involving a pheasant. The guy's last name is Pheasant. And so U.S. versus Pheasant is a case against Mr. Pheasant, who is riding a dirt bike in Nevada. And he's out there riding on his dirt bike, and a Bureau of Land Management officer decides that he doesn't have a tail light on his license plate, and that violates BLM rules. You can't ride around in the dirt with no tail light on your license plate. So he pulls him over, and this guy is right out of central casting. His immediate response is, "Am I being detained?" And as the course of the conversation goes on, and the BLM officer tells him that he's in violation of this BLM rule for not having a tail light on, he ends up giving him a relatively small fine, $100 fine for not having a tail light on. And the guy rides off into the distance with his fist in the air yelling, according to the court. I mean, it's a perfect description, right? This is a relatively small fine, but it's the principle of the thing, the idea that you're being fined for this. So he goes and gets a federal public defender to fight the taillight fine.
So a public defender.
Federal public defender. And the federal public defender says, not only will I help you address this relatively small fine, I think BLM didn't have the authority to impose this fine on you in the first place, because this is a criminal rule that is being imposed not by Congress. Congress never voted to make this a rule. It's the Bureau of Land Management that's the one that's deciding to create criminal statutes, and I think that's a problem. And the federal district court in Nevada said, yeah, this is a violation of the non-delegation doctrine. Congress can't delegate away to the Bureau of Land Management the ability to create criminal statutes that impact people, could potentially jail people if you don't pay the fine. So that's the basic story of this case. I think it's one that I think you can sort of imagine yourself in, or at least the frustration. And maybe the story here too is that Pheasant didn't take it lying down. He decided, I'm going to fight this, and the result is that it could actually have an impact on every American's freedom.
Yeah, so maybe explore a little more like the non-delegation doctrine. Like, how's that come into play? What is it?
Yeah, so non-delegation is basically you won't find the word non-delegation in the Constitution, of course. Essentially, what the idea is, if you break out your pocket Constitution, we have an AFP pocket Constitution, if you would like one. But you break out your pocket Constitution and look at it. Article 1 begins with the lawmaking power is in Congress, right? And so it's Congress that has the power to make laws. The question is, all right, well, can Congress just give that power to someone else? Can it decide that some other agency, we're just going to give you lawmaking power? And when is it delegating lawmaking power versus, well, the ability to enforce the law includes the ability to make some rules, right? Or some regulations. And so, I think basically the answer in my mind is probably twofold. One is that, well, look, if Congress is just broadly saying, we assign to an agency the power to make laws, right? We have the power to make laws. We just give that to agencies. Well, that's clearly way too much. But then on a question like this, right? If it's a question about criminal statutes, if it's a question about taxing power, like these are really core things. If we expect our lawmakers to do anything, it's that I shouldn't be going to jail because someone I never had any ability to vote for decided that something is going to be criminal. And I shouldn't be losing taxes, having to pay taxes that I never voted for. That's taxation without representation is something you learn in elementary school, right? Yep. So that like delegating away that kind of power, either just broad power to make all the laws. And that's essentially what happened here. So, I mean, I'll read it off to you. This is, according to the Bureau of Land Management, this is the power that they have. Congress said you can, quote, make all needful rules and regulations respecting the territory or other property belonging to the United States, close quote. That's the grant of power. That is incredibly broad. So the Bureau of Land Management can make all needful rules and regulations for an area that's 245 million acres. It's a little larger than California and Texas combined.
Wow.
And Congress has essentially just said, go do whatever you need to do in that area. That looks like, if anything violates non-delegation, we elected members of Congress, and they basically just said, well, over 10% of the American territory, we're just going to let someone else decide what the rules are. That seems like that has to be a problem.
Yeah. Wow. That is a lot of land and a lot of power granted. Right. So on the podcast before, we've talked about Chevron deference.
Right.
How is that related or different from the non-delegation doctrine?
Right. So, yeah, I mean, these things kind of, go hand in hand, right? So non-delegation is, Chevron deference is about, the way I think about it is Chevron deference is about agencies taking more power than they were given, because basically the agency's deciding, well, Congress said we can regulate X. We're going to interpret that to mean also Y and maybe sometimes Z. We've got a lot more. We're finding new powers in the grant that you gave us. Non-delegation is about Congress just giving agencies more power than it constitutionally can give away, right? So it's kind of the other side of the coin. One is about agencies taking, and the other one is about Congress giving away.
So just turning to the Bureau of Land Management.
Yep.
You characterize how big they are, the amount of land that they control,
right,
which is pretty massive. Kind of where is the land, and what would ever happen if we sold some of it?
Boy, I mean, this is the thing. There's a whole separate lawsuit right now. Actually, Utah and some other states have brought, basically arguing that BLM should be forced to give some land back to the states. Because it's about 10% of American territory. It is largely, not exclusively, but largely in the West. In states like Nevada and Utah, it's the majority of the states. We can put up the map and the article that my colleague Mike Pepson and I wrote for the Federalist Society blog that includes this map. It's a whole, basically, if you're in the West, it's the majority of Western states is run by BLM.
Oh.
And so you have these places out there where, you look at the contours of what your state is supposed to be, and you know that you are electing people to represent your state. And yet the half or more of the territory of your state is actually regulated, not by the people that you're electing, certainly not the governor and the state legislature, but by unelected people in the Bureau of Land Management. And I think there have been other people who have written about this and the problems that creates. I mean, among them, housing, the problem of housing prices, right? And housing unavailability. Part of the problem with that is just, basically the land not being converted into places that people can live. And the impact that you can have if instead of BLM holding on to territory and refusing to do anything with it, if BLM was returning that power to the states and letting the states decide that, well, we're going to sell some of this property and allow people to develop it and allow people to be able to build housing, the impact that you could have just on the housing question, right? The tax base, all of those sorts of questions that, a lot of the problems that plague us that could be addressed by BLM deciding that, or Congress deciding that BLM needs to have less power over less land than it currently exercises.
Yeah, and a lot of those states are states that have seen a lot of growth recently.
That's
right.
right.
I mean, man, that probably does put a real pinch on housing prices.
Right. Yeah, that's right.
Yeah. Casey, I was really struck as you're kind of describing the Pheasant case about, here's a guy out riding a dirt bike. And as you know, on this podcast, we've gotten to interview just ordinary people, right? That have taken these cases. They've paid kind of the price for taking a stand. And I guess I'm struck by, here's a guy out riding a dirt bike, and all of a sudden it's a case that probably is going to head to the U.S. Supreme Court, right?
It certainly could very well. I mean, and certainly is already in the Ninth Circuit now, waiting on a decision from the Ninth Circuit right? He wasn't anticipating that day when he decided to go ride his dirt bike.
Yeah.
That he was going to make law. That wasn't the plan.
Yeah.
So.
Nor was it the plan of the BLM guy that pulled him over.
Right.
I mean, he generally, I guess, thought he had the authority to do that. And so he did. But I mean, that's really what happens in these cases, right? It's just ordinary citizens who end up doing this. And I remember the case of the coach that prayed, and you were involved in that case, right? As well.
Right, yeah.
And, they just make, one day they decide to do this. And then next thing you know, they're in the middle of this, embroiled in this controversy that's heading to court.
Yeah. I mean, most of these cases, that's really just the way they work, right? I mean, Loper Bright was not a group of fishermen who were passionate about something called Chevron deference. They were passionate about herring. Right. They wanted to fish. And, and government made the case about Chevron deference because it needed to be able to do that in order to justify the power that it was imposing on them. And so that's often the case with, these conflicts between government power and individuals. You have individuals who are just trying to live their lives. And then you've got government that, basically makes their day about something a lot bigger than that. Yeah. Because of its desire to impose something on them. Yeah.
But there is something, and this is a kind of a theme we talk about on this show, right? Whether it's somebody who decides they've had enough and they're going to go out and fight a regulation or a tax increase or something, right? But there's something inside these people who I think are real heroes, right? Yeah. Who decide that, this just what happened to me wasn't right. I'm going to pay whatever price there is to pay. And it's usually a pretty high price, whether it's financial or not. There's a high price to be paid, but they're winning the victory for everyone else by doing that, by stepping up and kind of taking on the system.
Yeah, no, that's absolutely true. I mean, how many people got a taillight infraction fine over the course of however many decades from the Bureau of Land Management, and then just decided, well, I'll just pay the fine. And how many federal public defenders, for that matter, had cases come to them and said, well, look, here, I mean, there's not really much to fight here, right? And then it wasn't a thing. And so it really, I mean, I think it basically is a great illustration of, the impact that you can have, but especially when you're willing to have that kind of impact, when you're willing to say, look, there's the easy course here, which frankly, most of us would take. Sure. There's the easy course here. There's also the path that would have me say, what's really the opportunity here? Yeah. How can this make a difference in people's lives?
Well, I even think like Coach, was it Joe Kennedy, right? Yeah. When he did that, his wife worked for the school district.
Yeah, right.
And she was like in HR for the school district. And I'm thinking, what a terrible price, she had to pay. Right. And I'm sure there were a lot of discussions over dinner at that home that, we probably don't even know about. Right. So it's incredible. Turning a little bit from the Ninth Circuit to the Supreme Court, the Supreme Court is going to take up a case that involves user fees when it comes to phone and internet businesses. Talk about that case.
Yeah. So these are connected. So if you take out your phone bill right now, look at your phone bill and you will see, on your cell phone bill or whatever, there's something called the universal service fee that you're charged. And so what this is basically in the 70s, I believe it was, Congress decided that they needed to, the cell phone or the phone companies and others came to them and said, well, in order to be able to expand access, build new phone lines, that kind of thing, we're going to need basically these resources coming from the government in order for us to build these lines. And so essentially the way that this system has worked is that Congress gave the FCC the ability to impose a universal service fee on your phone. Congress never decided how much this fee should be, gave no real indication of any guidelines for how it should work, anything like that. Instead, they just told the FCC, you figure it out how much people should be charged to pay for this universal service. Congress, the FCC then decided, well, we're going to create this separate private entity that will work with the phone companies. And so that private entity working with the phone companies will find out how much the phone companies need in order to continue to expand the services. And then they'll come and tell the FCC, and the FCC will charge us, will tell the phone companies to put that on the phone bill. So it's quite a great gig if you can get it. So basically, this is, again, in the Pheasant case, that's a case about a criminal statute, basically, that is being imposed not by people you've elected, but by Bureau of Land Management. This is taxation without representation. It may not be a large tax, but neither was the Stamp Act that was the beginning of the Revolutionary War. It wasn't that much.
Yeah.
It was the principle, the idea that you can be taxed and that the people you voted for aren't even the ones imposing taxes on you. And that's what's happening in this universal service fee, is you got the FCC effectively outsourcing to a private entity, working with the people that will end up getting the funds from the universal service fee. They all work out how much money they need from you and then impose that on your phone bill. And so that's what's happening in the universal service fee case, Consumers Research versus FCC. And the Supreme Court just decided to hear that case. So sometime in the spring, they haven't scheduled it yet, sometime in the spring, probably March or April, the court will hear argument in that case, and hopefully will decide that this violates this non-delegation doctrine. Congress can't just give the FCC or even private parties this power to make these kinds of decisions.
And the reality of that is that these private parties, these private companies are actually deciding how much that fee is, right?
Yeah.
I mean, they're just, they could be making it up. We don't know if how their math is, right?
Yeah, no, that's exactly right. And of course, Congress isn't responsible for that.
Sure.
Congress is able to see, this is all happening. And so if Congress, of course, can sort of sit and if people don't like it, then it's, it's those people over at the FCC making these decisions. When it's Congress that handed them that power.
Sure.
So not to speak ill of you and your friends in Congress now, Jeff.
Understood.
You're not there yet.
Yeah,
We're recording this. You're not there yet.
Right.
So
he's going to there and improve that.
Right, exactly. It's still those people for now.
Those people, those rascals for now.
Yeah.
How did this case get to the Supreme Court?
Yeah, so this is basically, they have challenged this in a few different places. Folks at a law firm called Boyd & Gray, representing Consumers Research, which is a nonprofit organization that works on these.
Boyd & Gray from
Boyd & Gray Associates.
The Bush years.
That's right. So the firm that he created. And so Boyd & Gray Associates is a law firm that has been representing Consumers Research, which is a nonprofit that deals with these kinds of issues. And so they brought several of these lawsuits around the country. The Fifth Circuit decided, yes, this does violate the non-delegation doctrine. Now, we've talked a lot about the non-delegation doctrine here. I will say that the challenge right now is that the court has acknowledged that there's a thing called the non-delegation doctrine. The problem is that they haven't really enforced the non-delegation doctrine in almost a century. And so essentially what they've said is, anytime Congress gives any kind of what's called an intelligible principle to the agency, then that's close enough for government work. If an intelligible principle ends up becoming this incredibly broad grant of power that they're giving to agencies. And so really the non-delegation doctrine that I've been describing or been saying is a thing, the court has said it's a thing, but it's really been lax in actually telling Congress, you have to be the one to exercise legislative power. You can't just hand that away. And so both of these cases, but especially now the Consumers Research case, because it's there at the court now, give the court an opportunity to put some teeth back in this non-delegation doctrine and say to Congress, you got to do your job.
Yeah. Does the Loper Bright case and the way the Supreme Court decided that case, does that become precedent for how they might decide these cases?
It won't directly, but it certainly helps in the sense that, I think Chevron deference was, one of these other sort of ways that the court had interpreted, the power of agencies that had really, had enormous consequences. And that was a big deal to ask the court reverse course on Chevron deference because of the how much the administrative state had relied upon it. And I think now having the court having taken that step, I think there are a lot more people who think, well, look, it is possible then that the court is finally realizing and willing to take on the problem that has been created by basically the non-enforcement of what the Constitution requires. And so I think there's hope now for people that after the Loper Bright decision, some others from the court recently, that the court's taking a lot more seriously enforcing the constitutional rules around this stuff and moving back to the people's elected officials the responsibility that they're supposed to have.
Well, I would think it would be hard for in a justice's mind to say on the one hand, Congress should have spelled this out if they wanted to give you the authority to do it in Chevron. They should spell that out.
Yeah.
And then in this case to not do that.
Yeah. Well, and I think after Loper Bright, there's basically there's at least one risk coming out of Loper Bright, is that Congress might respond to Loper Bright by saying, well, instead of agencies interpreting broad power for themselves, why don't we just give them broad power? Why don't we just very clearly say, essentially, agency, go and make all the needed rules, around, environmental protection or around, regulating interstate commerce or whatever, and that wouldn't be a Loper Bright problem. Agency wouldn't have to creatively interpret its power under Loper Bright if Congress was just saying, do whatever you want, right? Then everything's going to fit.
Right.
But it would violate non-delegation then if they're saying, we hereby give you the authority that we have under Article 1 to do whatever you want to do.
Sure.
We hereby dub you Congress now.
Right.
Then that's the next step. And so that's where I think, the court's decision in Loper Bright wouldn't mean very much if Congress then is able to just say, we give all of our power away to these unelected bureaucrats to do whatever they want to do.
Those rascals, they might actually do that.
That's right. I know these. That's why I'm so glad you're going to show up there next year. Right.
Well, it really seems to me that potentially if this goes to the Supreme Court and right sizes government, kind of puts it in line with the way the founding fathers saw it and makes Congress do their job, like I owe a debt to Mr. Pheasant.
That's exactly right. I mean, these people who, as you said, people who you didn't expect when they were having their coffee that morning that they were going to have this kind of impact. But that's sort of American history, right? Is that all kinds of people who are famous not for a long list of other things they did in life, but for the one moment when they said, "Look, I'm going to stand up and refuse to allow this," and they ended up having an outsized impact. That had an impact on their life, and they ended up impacting other people's lives as a result. So,
well, Casey, thank you so much. This is really illuminating. I'm smarter for listening to it.
No, absolutely.
This is great. Talking about Mr. Pheasant kind of reminds me what we always say here, which is liberty and freedom are easily taken for granted. Don't take it for granted. Go out there and defend freedom and liberty. Thanks for joining us.
Thank you for listening to American Potential. You may listen to more stories from Americans working every day to expand freedom and opportunity in their communities by visiting AmericanPotential.com.